I want to quickly bring into this conversation Justice S.N. Dhingra, former judge of the Delhi High Court. He's one of the signatories to this letter that called for an impeachment and these judges, former judges and legal luminaries have said this is an attempt to intimidate the judiciary. Justice Dhingra, welcome, sir. Why do you see this? Why do you see this impeachment motion moved by over 100 MPs seeking the removal of Justice Swaminathan as a brazen attempt to browbeat judges, sir?
You see, as a judge, myself, and you see what is reported from in newspapers, we have seen these politician advocates browbeating judges inside the court. These advocates who are in politics and who consider themselves above law, they keep browbeating judges in the court. Now, this is for the first time, this is an unprecedented move that you start impeachment proceeding against a judge who has delivered judgment which is not to your liking. So that is something very dangerous for the whole institution. You have remedy, the remedy of appeal to the division bench, remedy of appeal against division bench to the Supreme Court, SLP, then writ petitions, bypassing all the remedies which are available to you, you have started impeachment proceeding on the ground that this judgment is based on ideology. You can brand any judgment being based on ideology. So you get a weapon of demoralizing judges on the ground that the judgment is based on ideology. And
so that's a big
impeachment, using impeachment as a weapon to threaten the judges. I consider this is highly insensitive, highly objectionable, and preposterous.
Okay. Justice Dhingra, how will concerns of alleged ideological bias or deviation, from a division bench ruling, these are some of the issues that have been raised by opposition MPs. How will these be addressed? How will their concerns be allayed, sir? Only by appealing in a superior court?
You see, every judgment can be appealed before the superior judge on the basis of merits, not on the basis of individual judge's qualities or his bias. If the judgment speaks for itself, you can challenge the judgment that, look, in the judgment, these are the paragraphs which show that this is contrary to law. A judgment has to comply with constitutional norms. And High Court judgment has to specifically ensure that it is constitutional. If the Constitution provides that all communities are equal before law, all religions are equal before law, and you cannot prevent a religion from performing its rituals because another religion is objecting, or you cannot create a situation that law and order will the situation of law and order by your own deliberate act and accuse the judge that, look, because he has given the judgment, so law and order situation will be created, whereas you are creating law and order situation by not allowing rituals to be performed in accordance with the judgment.
Okay, so let me then take it specifically, sir. The impeachment notice cites 3 very specific instances and serious ones at that. Compromised impartiality, a conduct which is not seen as secular, undue favoritism, and a pattern of decisions reflecting a particular ideology, sir. Can these concerns be dismissed as wholly inadequate, as the letter seems to do, without acknowledging, if proven, that these are very, very serious charges, sir?
You see, these charges can be leveled in respect of any judge for any judgment. You call a judgment unsecular. Why? Because it is not to your liking. Because in such cases, there will be 2 parties. One, the petitioner, other will be the opponent. if petitioner belongs to A community and opponent belongs to B community, the decision has to be given in favor of either A or B. Now, the moment you give decision in favor of A community, then you are non-secular. If you give decision in favor of B community, you are non-secular. What is the definition of secularism? It is for the judge to decide which way the rights or constitutional right of the party lies. Not the secularism is not going to decide how the judgment is going to be delivered. These are constitutional rights given by the Constitution. And
Yes.
I may give similar 20 judgments in which I uphold the right of constitutional right of a party. Does that mean that a judge has no right to uphold the constitutional right of a community or party, and he can be branded unsecular? It is something unheard of that you
Okay.
say that this judgment is unsecular, because a judgment has not to stand the test of secularism. I'm
Yes.
sorry. Judgment has to stand the test of constitutionality, whether the consideration have been on merit or not on merits. If the
Fair enough,
judgment
sir.
is on merit, then where is the issue of secularism?
Absolutely. So let me then, and permit me, Justice Dhingra, to go into a specific charge. And in the media, it's extensively been reported, TKS Ilangovan of the DMK has alleged that Justice G.R. Swaminathan intentionally, according to him, overruled a two-judge bench to aid what he called was a BJP-backed agenda, even comparing the Deepam order to a Babri Masjid-style attempt to create a communal flashpoint. Now, sir, how would you look at this, that the charge that is being leveled, a single judge overturning a division bench order, sir?
You see, a single judge can differ with the even Supreme Court judgment. If the judgment is not applicable to the facts of the case, he can say this is not applicable and I don't follow this judgment. There have been cases even before me where I refused to follow Supreme Court judgment. There were two Supreme Court judgments, one in favor of plaintiff, other in favor of defendant. And the earlier judgment, which was in favor of the plaintiff, was by three judges. The later judgment was given by two judges of Supreme Court without considering the earlier judges judgment. So I did not follow even Supreme Court judgment. Where you see, overruling a judgment is not something new in India. Supreme Court itself has been overruling its own judgments on the basis of very ideology itself. See, ADM Jabalpur judgment was overruled later several times by many judges. And Golaknath judgment was also overruled by later judgments.
Okay.
See, the ideology of earlier judges was different from later judges. So the later judges overruled the earlier judgment. This is, they considered the constitution, the interpretation of constitution given by them as the correct interpretation, and the earlier interpretation was overruled. Is there something new in it? See, why we refer the, you see,
Past
benches,
precedents.
five judges bench, then seven judges bench, then 11 judges, 13 judges, because
Sir?
we consider collective wisdom of more judges will be more
Yes.
better instead of two judges, three judges. So that is the reason that
Okay.
overruling takes place. Overruling is a regular feature of this country, judiciary.
Okay.
It is not
So,
something
Justice
new.
Dhingra, if an order is not followed by the government or the administration, can a High Court judge go beyond issuing contempt of court notice or subsequently proceedings? Can he, for example, direct authorities, not the state police, but a central armed police force to provide security? Or would that be seen as judicial overreach? And in
How
your
can
view,
it
how
be?
should this issue have been addressed, sir?
You see, do you think the orders and judgments passed by courts should be only paper judgments, not implemented by the administration. A judge and a court must ensure that the judgment given by him, if not overturned by the superior court, must be implemented. He has to devise methods of getting the judgment implemented. Nobody can be allowed to sit on the judgment on any ground whatsoever. Otherwise, all courts will become mere paper tigers. You pass a judgment, and the administration says, sorry, we cannot implement it because of law and order situation. We cannot implement because our ideology is different. You can take any number of excuses. I don't
But
think
would that not be
that a
judicial
judge
overreach
is
and
not
judge going into
is
the
weak
into the
enough
domain of the
or cannot
executive, sir?
get the judgment implemented. He has to get the judgment implemented.
Fair enough. Justice Dhingra, for joining me here on this India Today special broadcast. Many thanks, sir. We'll be tracking the story very closely.